Hi, my name is Karen Kohler of Strip Matter Kessler Whalen Withy and Coluccio, and today we're going to talk about depositions. I'm a lawyer, so I love them. You're not. So you're going to be scared and you're going to be worried and you're not going to want to do it. Well, we're going to give you some rules and some tips so that you can have confidence in knowing that you're going to be able to do the very best job you can. The most important rule of all is to tell the truth. If I could tell you one rule, and only one, it would be tell the truth. Don't tell a little lie, not even a little white lie. One little lie and another little lie equals more lies that you got to remember. The more lies you tell, the worse it's going to get. Don't do it. If you lose your credibility, you lose everything. The worst thing that can happen for you is for a jury to think that you're dishonest. If they do that, your case is over. In this scene, the lawyer is going to ask about whether the witness had medical conditions or problems before this incident. Let's see what happens when the witness isn't truthful.
Ms. Johnson, following this incident, you suffered a neck and shoulder injury with pain and numbness running the length of your arm to your fingers. Am I right?
Yes.
And you claim all of these problems were caused by the defendant?
Absolutely.
Before this incident, had you suffered similar symptoms?
No.
Are you absolutely sure?
This is the first time I've ever had anything like this.
Do you remember treating with a doctor 10 years ago for the same symptoms?
No.
Would it surprise you to know that I obtained the records of your former doctor that show you had a previous shoulder injury?
Object to the form.
Can we take a break?
Ms. Johnson, please answer the question.
I don't remember.
Let me show you the records. Do these refresh your memory?
You know, this is so long ago, I'm not even sure these are my records.
Ms. Johnson, is this your name and social security number?
Yes.
Ms. Johnson, these are your records, aren't they?
Yes.
Lawyers are trained to look for inconsistencies. That's why they ask questions over and over again. Here the plaintiff tries to make her case better by not telling the truth. Let's watch what happens when this case goes to trial.
Members of the jury, my name is J.D. Smith, and this case is not what it seems. The plaintiff claims to have been injured in this incident, and we intend to show that the plaintiff has previously had these injuries before. Instead of coming into this courtroom and telling the truth, the plaintiff is continuing to cover up these injuries. In a deposition taken earlier this year, in my office with the plaintiff lawyer present, the plaintiff was sworn under oath to tell the truth and nothing but the truth. The plaintiff chose not to tell the truth and continued to try to cover up these injuries. Could you please show the video clip?
This is the first time I've ever had anything like this.
Do you remember treating with a doctor 10 years ago for the same symptoms?
No.
Would it surprise you to know that I obtained the records of your former doctor that show you had a previous shoulder injury?
Object to the form.
Could we take a break now?
Ms. Johnson, please answer the question.
I don't remember.
Let me show you the records. Do these refresh your memory?
You know, this is so long ago, I'm not even sure these are my records.
Ms. Johnson, is this your name and social security number?
Yes.
Ms. Johnson, these are your records, aren't they?
Yes.
When you go into the jury room, we're going to ask that you render a verdict based on the evidence. We believe the plaintiff is not credible, and the evidence has shown that. Therefore, we ask you to render a defense verdict.
This bad result could have been avoided if plaintiff had just been straightforward. Let's look at this scene again and see what would have happened if plaintiff had followed rule number 1 and told the truth.
Ms. Johnson, following this incident, you suffered a neck and shoulder injury with pain and numbness running down the length of your arm to your fingers. Am I right?
Yes.
And you claim all of these problems were caused by the defendant?
Absolutely.
Before this incident, had you suffered any similar symptoms?
Oh, a long time ago I had some achiness in my neck and it went over into my shoulder, but it certainly didn't run down my arm or cause any numbness and tingling in my hand like I have now.
And how long did it last?
Oh, it went away all by itself after a couple of weeks.
Do you remember treating with a doctor 10 years ago for the same symptoms?
You know, I might have, but if I did, I only saw him one time, and I certainly didn't need any physical therapy or surgery like I did this time.
Let me show you the records. Do these refresh your memory?
Yes, thank you. Yes, it's exactly as I said. I saw the doctor one time, and everything pretty much cleared up by itself with just a couple of aspirin. And I remember I overextended myself in a yoga class, and it was no big deal. It went away by itself.
Let's compare how these facts would be used in trial.
You've heard the defense try to make a big deal about the fact that Miss Johnson saw a doctor 10 years before this incident ever happened when she tweaked her neck in a yoga class. She didn't try to hide this from them during the deposition. She told them about it at that time. And we've told you about this during the trial. There's nothing to that defense being made here today.
Be prepared, do your homework, and don't wing it. There's nothing that the other side likes more than to have a stressed out person having their deposition taken.
When did the incident occur?
You mean the date?
Yes.
You know, I'm not really sure.
Do you know the year?
The year of the incident?
Yes.
Okay, let me, I think it was 2002. It could have been 2003, I think. But, you know, it could have been 2001.
Well, what time of year did it happen? Do you know what season? Spring, winter?
I don't exactly recall.
Okay, what time did it occur?
The incident?
Yes.
Okay, it might have been, okay, I think 2002. You know, it could have been 2003. At least I think. It might have even been in 2001.
If you don't remember everything, that's fine. But remembering nothing, that's not fine. Here are some ways that you can prepare for your deposition. Review the police or incident report if there is one. Look at the medical records from before and after. Review your interrogatory answers or documents produced. Look at anything else that your attorney asks you to. If you still can't remember, the best answer is, I can't remember at this time. Whose deposition is this? It's your deposition. So own it. If you need to take a break, take one. If you need a glass of water, ask for one. Don't let them be rude to you. Make them treat you with respect. This is your deposition, not theirs.
Ms. Johnson, you need to speak up.
I'm sorry.
I'm having a hard time believing anything you say.
Well, objection, counsel. You're harassing the witness.
I'm telling the truth.
What?
I'm having a hard time sitting here right now. I'm telling the truth.
Look, you need to listen for a minute. We're going to do this one more time, and this time around, I want a clear answer from you.
Objection. I want the record to show that counsel is harassing the witness.
Okay, I'm hurting. I'm in pain.
Okay, you brought this lawsuit. You should be able to tell us why.
Objection.
Your lawyer is here to make technical objections. But if you don't stand up for yourself, it's going to look like your lawyer is trying to interfere. Let's try this one again.
Ms. Johnson, you need to speak up.
feeling very well. I'm having some trouble sitting. Do you mind if I stand?
Of course.
Thank you. Thank you.
Okay, let me just cut to the chase. I'm having a hard time believing anything you say.
Sir, I am an honest person, and I am trying my very best to answer your questions, but I believe that you are trying your best to confuse me. When you talk to me in that way that you do, it hurts my feelings and it makes me worthless. Worthless.
I'm sorry. I don't mean to confuse you or to twist you around and make you feel uncomfortable. I'm sorry.
Before we go any farther, could I have a drink of water?
Sure.
Yes.
Thank you.
The other side will speed up their questioning. They'll do it so that you'll speed up your answering. Don't fall into that trap. Slow it down. Breathe.
Did you
No.
notice anything unusual
No.
about the incident?
Yeah.
Could you
No. No, I couldn't.
could you see the defendant?
Oh, yeah. Oh, yeah. Yeah, I could see the defendant.
At any time?
Before or after?
Before?
No. I couldn't.
Okay. The best way to deal with fast talking is to start off nice and slow, even on your own name and address. Take a big deep breath, tap your feet, count to 3 in your head. Whatever you have to do, keep it nice and slow.
Did you miss any time from work following the incident?
Yes.
Can you be more specific?
I was totally off work for 3 months.
Was that all that you missed?
No, my doctor suggested that, or actually more than suggested, that I go back to work part-time, and I did work part-time for another 2 months.
Lawyers ask complicated questions and use big words, and they go on and on and on until they run out of breath. Your job is to understand the question. Don't feel bad if you need to ask them to repeat it so that they speak like a normal person in a way that you can understand it. Asking the right question is their problem, not yours.
Subsequent to this incident, I understand that you were incapacitated for a substantial period of time. But thereafter, you engaged in the requisite rehabilitation and made excellent progress. According to your physicians, and you were able to return to your usual pursuits without any undue difficulty, thereby confirming your complete recovery. Am I correct?
Yeah.
Well, just a minute. Don't answer that question. I object to the form of that question.
Am I also correct that the emotion sequelae that you experienced primarily occurred during the initial acute phase of injury following the incident, and that as you begin to recover, and indeed as you sit here today, such sequelae have subsided or entirely dissipated, and in the event would be de minimis at best?
Yeah.
I object to the form of the question.
Would that be a yes?
Well, yes. I guess so, yes.
If you answer questions that you don't understand, chances are you've blown it. Let's replay this deposition question again.
Subsequent to the incident, I understand you were incapacitated for a substantial period of time, but thereafter you engaged in the requisite rehabilitation and made excellent progress. According to your physicians, you were able to return to your usual pursuits without any undue difficulty, thereby confirming your complete recovery. Am I correct?
That's too many questions all at once. Could you ask them separately?
Subsequent to the incident, I understand that you were incapacitated for a substantial period of time, but thereafter you engaged in the requisite rehabilitation and made excellent progress according to your physicians, and you were able to return to your usual pursuits without any undue difficulty, thereby confirming your complete recovery. Am I correct?
That question has too many parts. Could you just break it down for me?
Am I correct that the emotional sequelae that you experienced primarily occurred during the acute phase of injury following the incident? And as you began to recover, and indeed as you sit here today, such sequelae have subsided or entirely dissipated, and in any event would be de minimis at best.
Those words are really large and confusing. Could you ask me the question in simpler language?
You didn't suffer any emotional injury, did you?
Oh, of course I did. I saw a psychologist for several months, and I know you have her records. That was an extremely difficult time for me.
When you answer questions in a deposition, they're written down in a transcript. You can't take them back, you can't erase them, you can't wipe them out. They're there. So when you speak, answer with care and get it right.
What was the first thing you remember when you regained consciousness after the incident?
How would you expect me to remember that? I remember thinking, wow, that was weird. Nothing much.
The witness is downplaying what happened to her. If it doesn't matter to her, who's it going to matter to? Surely not the jury. The next question is the big one. It explains why you are entitled to damages for pain and disability. Here, the witness bungles the answer.
How has your life changed because of this incident?
I don't know. It's changed, but I deal with it. Things used to be better than they are now. Now they're worse. Gee. Lots of ways, but golly, I can't really think of any right now.
If you are prepared and take the time to answer this question, thinking it through carefully, you will be able to give specific examples and answer it thoroughly.
How has your life changed because of this incident?
It's changed in a great many ways. I used to be really active, and I took care of my house, my family. I worked. I was pretty physical. I mean, I wasn't a jock or anything, but I biked and I played tennis with my friends. I loved gardening. Now I can't even sit at the computer for 20 minutes without my neck freezing up on me, pain shooting down my arm, my fingers going numb. And the most physical I get is walking around the block.
If you understand the question, just answer it. Don't volunteer this or that. Just answer the question. Everything you say can and will be used against you.
Where were you going at the time of the incident?
Yeah, my alarm went off at the regular time that morning. I remember because I was going to work, and then after work I was going to go meet a friend for dinner, and it was a really typical day at work, but maybe I was a little tired afterwards, and I hadn't really eaten very much that day, because I was really looking forward to this dinner. Boy, was I hungry. My doctor gets so mad at me sometimes because I don't eat right. I mean, mainly it has to do with my health problems. I have diabetes. I don't have the insulin diabetes. I mean, I could not tolerate giving myself shots, but I do take pills. And I think I took my pills that morning, at least. I'm not sure. Sometimes I don't, but usually I do. I'm sorry, what was the question?
No problem. Tell me a little bit more about your medications.
Oh, wow. I take a lot of them. They're really, God, I can't even remember the names of any of them right now, but mostly I take them at night, but sometimes if I forget, then I take them the next morning. And usually I remember to do that, but sometimes I forget, but usually I don't.
Do you ever get woozy if you don't eat and don't take your medications?
Whoa, now that you mention it, I do. And my doctor has just gotten really angry at me, but that's because I forget a lot of times because I'm really busy. I have a lot of businesses on the side, at least I used to before. And golly, I used to do doilies, but I don't do those anymore either. And I used to do computer programming on the side. But my memory is so bad since this happened that I can't do any of that anymore.
I've reviewed your answers to interrogatories, and I don't see any mention that you had a side business.
Of course you don't. Do you think I was going to report that income to the IRS? Of course not.
Really?
Let's replay that.
Where were you going at the time of the incident?
I was on my way to dinner with a friend.
There are two main reasons that your deposition is being taken. Number one, to pin you down. Number two, to discredit you. The other side is going to come across as warm and fuzzy, like they actually care. Whenever you think that they really do, just imagine two horns sticking out at the top of their head. Keep that thought.
I would like you to list every medical condition that you claim you sustained as a result of this incident. It's very important that you tell me about each such condition. I want to make sure that I know about every single complaint.
Well, I hurt my neck, I injured that, and my right shoulder. And when the pain gets really bad, it runs down my right arm and into my fingers, and my fingers turn numb.
Is that a complete list? Because I want to make sure we haven't missed anything.
And that's it.
But that wasn't everything.
Earlier today, in direct examination, you claimed that you injured your neck, shoulder, arm, low back, knee, and that you had concussion with headache. Am I right?
Yes.
Do you remember testifying in your deposition?
Yes.
Do you remember the court reporter being there?
Sure I do.
Do you remember that you were sworn to tell the truth under oath?
Of course I do.
And you said that you would tell the truth and nothing but the truth.
Yes, I did.
But your testimony today is different than it was then, isn't it?
Objection!
Overruled.
You changed your testimony today now that you're in front of the jury. Is that correct?
Objection!
Overruled.
Well, Ms. Johnson, let's just turn to your deposition. Your Honor, may I publish the deposition?
The deposition may be published.
Your Honor, may I approach?
You may.
Ms. Johnson?
Thank you.
Ms. Johnson, I ask you to turn to page 17, line 6. Isn't it true that I ask you specifically to list every single condition that you claim was caused by this incident?
Yes.
But you only mentioned the neck, shoulder, and arm, didn't you?
Objection, Your Honor.
This is proper cross. Overruled.
Yeah.
You didn't mention any knee, low back, or concussion, did you?
No, I didn't.
But a few moments ago, you told the jury you suffer from all of those conditions when your attorney asked you a question, didn't you?
Well, yeah, I did.
So were you telling the truth during your deposition, or are you telling the truth today?
Objection, Your Honor. That's argumentative.
I'll allow it. Overruled.
Could you please answer my question, which version is true?
Well, I guess today.
No further questions.
An attorney may also try to discredit you.
Okay, Ms. Johnson, right after the incident, you were lying on the ground and the police report says that you were yelling at my client.
I was.
You must have really been upset.
I was.
Can you tell me more about why you were so angry at my client?
I was just so mad. I mean, you know, as I sit here right now and think about it, I just get mad all over again.
I totally understand. But can you tell me a little more about your anger that day?
I can't stand stupid people. And this guy, this client of yours, I mean, he hurt me. And he wasn't paying any attention. I can't stand people who don't pay attention to what they're doing.
I totally understand. Can you give me an example of whether you've been that mad before?
Oh, God. Oh, God. Boy, I've been worse than that. I remember one time I was with some friends and we were out drinking and I had a little too much to drink, and I know you've been there yourself probably, and there was this woman in the room. I just did not like the way she was looking at me, and boy was she rude. I just could not stand it, and so I went over and I said some things that I shouldn't have said.
Sure.
You know, and before I knew it, there was all this hoopla and all this pushing and shoving and and I decked her.
Whoa.
Object to the form of the question.
Really?
Yeah.
So do you think you have an anger management problem?
Object to the
No.
form of the question.
Well, on the day of this incident, if you could have, do you think that you might have punched someone, like my client?
Hey, if I could have done it, he'd have been on the ground too.
I totally understand.
Just because a question is being asked doesn't mean that you have to know the answer. This isn't a test and you're not getting a grade on it. If you find yourself agreeing with what the attorney is asking, just remember, there are two horns sticking out of the top of their head.
Do you know what the defendant did right after the incident?
I'm not sure.
Do you remember seeing the defendant right afterwards?
Yeah, I'm not.
I believe he came up to see if he could help you.
He did.
Do you recall that?
Object to the form of the question.
I do remember him coming over to me.
And he would have been trying to help you
Well, object to the form of the
Of course he
question.
would.
because he was so concerned about you and wanted to help you in any way that he could.
Object to the form of the question.
Naturally.
A classic example involves time, speed, and distance calculations. Don't guess. If you do that, wrong information is going to be given to the other side's experts, and they'll poke holes in your case.
Can you help me with some details? How fast was the defendant going right before the collision?
Gee, I don't know. I was going about 55 miles an hour, and he was right behind me.
So at the moment of the collision, you had stopped suddenly, right?
Object to the
Yeah,
form.
Yes.
So he put his brakes on too. Do you think that he was able to brake, so maybe he was going, well, about 5 miles per hour before the impact?
Object to the form.
He could have been.
So he could have been.
Yeah, he could have been.
And how quickly did this happen?
Oh, fast.
Can you be maybe more specific? 3 seconds or less?
Object to the form of the question.
Might have been more.
Could it have been 5 to 10?
Object to the
It
form.
could have been.
And from the time you were going 55 to the time you stopped, how far did your vehicle travel?
Gee, I don't know.
Could it have been half a mile?
Object to the form.
Yeah, it sure could have been.
And did your vehicle move after impact?
I'm not sure.
Could it have moved at all?
Maybe.
You've heard the plaintiff attorney tell you that this was a serious accident, but the plaintiff herself told you that it wasn't. She misjudged traffic and came to a rolling stop and her car was bumped. You've heard from the defense expert that this collision occurred at a speed of 5 miles per hour or less and was equivalent to bumping into a curb or flopping into a chair. Ladies and gentlemen, with no crash, you should award no cash.
Don't guess. And don't help the other side by agreeing with their guesses.
Can you help me with some details? How fast was the defendant going right before the collision?
I don't know.
So at the moment of the collision, you had stopped suddenly, right?
Object to the form of the question.
I just stopped as the traffic stopped.
So he put his brakes on too. Do you think that he was able to brake so that maybe he was going like 5 miles per hour at the time of the impact?
Object to the form of the question.
I can't say how fast he was going.
And how quickly did this happen?
Fast.
Can you be more specific? Was it more than 3 seconds or less?
Object to the form of the question.
I have no idea. Time just seemed to stand still for me then. I don't know.
Well, could it have been, say, 5 or 10 seconds?
Object to the form of the question.
I have no idea.
And from the time you were going 55 to the time you stopped, how far did you travel?
I didn't measure the scene.
Could it have been half a mile?
Object to the form of the question.
I have no way of knowing.
Did your vehicle move after impact?
I don't know.
Could it not have moved at all?
Object to the form of the question.
It could have, it could not have. I don't know.
Never, ever, ever say never. Every time you say never, it gives another chance for the other side to take a swipe at you. Never, ever say never.
Have you ever had neck pain before?
No.
Are you absolutely sure?
I'm absolutely sure I've never had neck pain before.
Miss Johnson, do you remember having your deposition taken 6 months ago where you were sworn under oath to tell the truth and nothing but the truth?
Yes, I remember.
And do you remember testifying that you never had a neck pain before this incident?
That's true. I've never had one before.
And again, today, you gave the same testimony to the jury in this trial after having been first sworn to tell the truth and nothing but the truth.
Yes.
But in fact, you have had neck pain before, haven't you?
No, sir, I have never had neck pain.
Isn't it true that you saw Dr. Smith and he wrote in your medical chart that you had neck pain well before this incident?
I certainly don't remember that.
Your Honor, may I approach the witness?
You may.
Ms. Johnson, handing you what has been marked as Defense Exhibit Number 10, do you recognize the letterhead on this medical chart?
Well, yes, I remember seeing Dr. Smith in the past. Sure, I remember it.
But looking at Exhibit 10, isn't it true that Dr. Smith notes, quote, patient presents with neck pain, close quote?
That's what it says.
Are you saying the medical record is false?
I don't remember any, oh, wait a minute. Wait, I do remember, but it wasn't anything at all.
Can you answer yes or no?
Objection, Your Honor.
Overruled.
Ms. Johnson, isn't it true that you testified to this jury that you never had neck pain before?
Yes, it's true.
No further questions.
So those are the basics of how to handle a deposition. Let's go over the 10 lessons one more time. Lesson number 1, tell the truth. Lesson number 2, be prepared. Lesson number 3, own your deposition. Lesson number 4, breathe. Lesson number 5, understand the question. Lesson number 6, think before you speak. Lesson number 7, answer the question. Lesson number 8, the interrogator is not your friend. Lesson number 9, only tell what you know. Lesson number 10, never say never. Remember, depositions make up the backbone of many cases, so you can't treat them lightly. They are an essential part of a lawsuit that can either make or break a case. One last thing, your deposition might be videotaped. If it is, here are some quick tips. Don't look like a slob or be overdressed. Do wear a decent outfit from the waist up. Don't wear excessive jewelry. Do minimize accessories. Don't stare at the camera and psych yourself out. Do look at the attorney asking questions. Don't be fake. Do be real. Don't lose your temper. Do act pleasantly even when grilled. Don't be overly dramatic. Do watch your body language. Don't wave your hands around. Do keep your hands in your lap. Don't roll your eyes or shift them. Do remember your eyes speak volumes. Don't think with your eyes up. Do think with your eyes down. Don't relax until the camera is turned off. Do remember the camera is on. Thank you for watching this video. We hope it's been helpful for you. If you have any questions, be sure to ask your attorney.